You had a couple stories about some major court rulings that were handed down. First of which was a federal ruling out of Virginia about young adults and handgun sales. If you want to tell us what happened there.
Yeah, so this is a pretty significant ruling, right? Because the federal judge in this case, he's looking at the federal law. This isn't just isolated to Virginia, as I've seen some people, seem to believe in other reports that I've seen on this. This is actually about the federal laws. This applies everywhere. And it's about the ban on sales of handguns to 18 to 20-year-olds. And this judge found that that's not constitutional. It's not consistent with the Second Amendment. He did a review of the historical traditions surrounding sales of guns to those under 21. And he found that there's no historical support for this type of sales restriction, right? Or purchasing restriction, really. And therefore, it can't stand under the Bruin test that the Supreme Court handed down last year. So that's a pretty significant thing. This is, this law is from the Brady Bill. So it's from the 1960s. From the Gun Control Act. And so it's not very old.
Right.
There just weren't these sorts of regulations on entire age groups of adults during the founding era. That's the basic conclusion that this judge came to. And so I guess the rule is still, the law is still in effect at this point, because the judge has asked the plaintiffs and the defense for orders on what he should do now that he's determined that the law is unconstitutional. But that those are due next week, I believe. So we'll see maybe the next week or two. It's very likely that law will be enjoined, although it's also extremely likely this will be appealed. So, yeah. And a stay will probably be issued, but we'll have to see.
Yeah, I think it's probably likely that you said like the defense will appeal this ruling. But what I do think is interesting is this has been one area of the law that I think has been the most consistent post-Bruin, where we've seen, we talked about the assault weapon bans and the magazine bans, how different judges have kind of come down on different sides of that issue. But in terms of gun rights for 18 to 20-year-olds, I don't think I can think of a single ruling that we've seen post-Bruin where a judge has said that those laws have been permissible.
There's seen many.
Oh, has there been
there
one?
There was the Florida.
That's right. Ban. That's right. Yep.
And this actually extends back from before Bruin. You had a number of rulings on the 18 to 20-year-old restrictions. There was one in California. There was another one in this circuit. This is the Fourth Circuit that we're talking about here. Back a couple of years ago, that also found that you can't restrict. Actually, it was on the same law. The problem. So this is actually a repeat ruling, I guess I should explain, because there was a panel in the Fourth Circuit that found this restriction was unconstitutional. The problem was that became moot after the plaintiff in the case turned 21. Yeah. So it's no longer an active case, which is one of the hard parts, I guess, of challenging these age-based restrictions, because the cases can take several years, and an 18-year-old can turn 21 before the case ends, and they're no longer affected by this ruling. So it's that is another issue that these sort of plaintiffs face in these cases. But yeah, there was the one sort of outlier that we've seen, because you also had Texas lost their case on concealed carry for 18 to 20-year-olds.
Tennessee as well.
Yeah,
Minnesota as well. Yeah,
there's been a lot on the side of 18 to 20-year-olds gun rights at this point. But there was the Florida ruling, which is a panel of the 12th Circuit that happened this year, that found Florida has basically a total ban on sales of all guns to 18 to 20-year-olds. Now, that doesn't seem likely to stand given all the other the trend on this recently, but yeah, there has been that one significant outlier.
But it's definitely an interesting body of law to see, because there's been a ton of division post-Bruin where judges have gone any which way, and we only have the one case here, which, as you said, may not fully stand. And I think the legislature has even talked about repealing that law in the first place. So that could also be.
Although they didn't repeal it. I think there's a lot of the hope is left on this is probably going en banc in the 12th panel. This was a panel of 3 judges in the 12th Circuit that ruled in favor of this law. And now it's going to be heard by the full circuit, which is relatively conservative circuit. So we'll see how they come out, but I would be very surprised if that law survived scrutiny there, especially because it's a much broader ban. It's a ban on basically
total sales,
a total ban on buying guns by 18 to 20-year-olds. But yeah, so that's a super significant ruling. And then we had another one, right?
I was gonna say, you wrote about this time a gun law actually being upheld, and it's another federal provision under the Gun Control Act about people that are involuntarily committed being prohibited from owning guns, and the court found that's okay, that's permissible.
Yeah,
tell us
so
what went into that.
Similar situation where the judge looked at the historical tradition of firearms regulations during the founding era, because that's what Bruin requires, right? And except this time he found that there was a significant tradition of barring specifically people who are dangerously mentally ill, not just all mentally ill, not just anyone who has any sort of mental illness diagnosis, because that's not what the law applies to, right?
Sure.
The law applies to people who are adjudicated as a threat to themselves or others, right? That's the standard in the federal law. So they have to actually have been found to be a threat to themselves or others and committed on that basis. So, it's not just anyone who's been diagnosed as bipolar or has depression or what have you. So on that basis, he found that there is a historical tradition that dates back to the founding era and before and after, which allows the government to disarm dangerous mentally ill people. Now, he did admit that there was not a exact replica of the modern version of this law in the founding era. So maybe, I don't know, perhaps on appeal there'll be some more controversy over this. We'll see. But he said that the way that government officials operated in the founding era is consistent with the fact that they were allowed to take firearms from somebody who was considered dangerously mentally ill.
And I think this is interesting, one, because we've seen sort of a split again in terms of the prohibitory offenses that are listed under the Gun Control Act about what can stand and what can't. For example, felon in possession laws have been pretty consistently upheld.
Yep.
But you've seen some of the more controversial rulings like the DV restraining order ruling and the federal felony indictment ruling. So this is one where obviously the court erred on the side of the federal government and said that's permissible. But I think it also might have implications based on the criteria he laid out, potentially for red flag laws. We haven't seen too many federal red flag law challenges, but if there's a history, as this judge is saying, of taking guns from people that are dangerously mentally ill, I think that's an interesting criteria to look forward, as inevitably the red flag laws will get challenged.
It could be. There was one ruling against red flag laws in New York.
In New York, yeah.
Right. But
I believe that centered more on due process rather than the actual act of taking the firearms from.
Which I think is probably the more fertile ground for legal challenges anyway. But it could be. None of these things are necessarily fully settled, and the Supreme Court is probably going to have to step in sooner rather than later on some of these things, especially because they're dealing with federal laws. Now we're seeing several of these federal laws get struck down, at least provisions of them, and that's where the Supreme Court is generally more apt to intervene and explain itself in those cases in a much quicker manner than otherwise. So